bonjour. Distinguished member of the delegation, on behalf of the committee, let me extend a warm welcome to all present here. First of all, I would like to congratulate you for your engagement in this important dialogue with the committee, for the submission of the State Party report, and for the information and updates presented in the opening statement by His Excellency, Mr. Hennet. The committee is aware of the situation in Cameroon, particularly in the areas covered by the UN Convention Against Torture. Cameroon, for several years, has been facing threats to peace, security, and instability, attacks by non-state armed groups, in particular Boko Haram in far north region, and militias of secessionist movements in northwest region and southwest region, as well as intercommunal clashes and hate speeches. A reality with multiple crises and problems that need to be addressed by the government and local authorities, and it requires considerable efforts. Our today dialogue within the committee focuses on challenges you face in the field of preventing and combating torture, and represents an opportunity to identify solutions and to return to a normality where human rights are part of the political agenda and the general objective of the society. Peace and respect for human rights are the most important values in a society, and there are no other options. Around these values, we will discuss this today, and I hope that we will have a sincere and efficient dialogue for the benefit of the persons protected by the provision of the Convention, and with the relevant impact of the work of the state authorities in prevention of violence, ill treatment, and torture. I also hope that this dialogue will be a good avenue for the civil society organizations, lawyers, journalists, human rights activists in your country to continue their efforts towards building a society free of violence and torture. In my presentation, I will refer mainly to the issues covered by the Article 1 to 9 of the Convention. And my colleague, Professor Mr. Jorge Contese, will raise questions and comments under Article 10 to 16 of the Convention. Before I proceed with the specific questions, I would like to mention that Cameroon is already a party to the most important human rights instrument and has ratified several conventions drawn up under the aegis of the United Nations or the African Union, such as the Convention of the Rights of Persons with Disability and the Protocol to the African Charter on Human Rights and on the rights of persons with disabilities in Africa, and has also begun the ratification process for several other important instruments. The State Party is a signatory to the Rome Statute of the International Criminal Court and collaborated with the court, but has not begun the ratification process. Cameroon practiced a de facto moratorium on the death penalty, and it intended to continue aligning its legislation with international standards. The implementation of the fundamental legal safeguards is the first topic that I would like to discuss with you from the perspective of the legal provision, but also the practice. First of all, thank you for the information presented in the State Party report. We appreciate the efforts to introduce provision on fundamental safeguards in national legislation and the initiative on free legal aid provided to a number of beneficiaries. However, there are numerous reports and submissions indicating to violation of the fundamental legal safeguards, and namely access to a lawyer, access to a doctor, and notification of rights and custody. Before I move on to the topics about access to a lawyer, I would like to start with a question about detention records. In accordance with Article 121 of the Code of Criminal Procedure, the period of police custody runs from the time when the suspect arrives or is taken to the police station or gendarmerie brigade. This time is recorded in the register and in the minutes of the hearing. However, suspects are often recorded in the so-called main register after their arrival at the police station or gendarmerie brigade, which arbitrarily prolongs police custody. So my first question is, what stage are you at with establishing the central detention register? Is this register already functional for all police and national gendarmerie detention facilities? You have some references in the State Party report about this initiative to establish the central register, but it's not clear whether this is already in place or not. Under Cameroonian law, the condition of arrest are governed by several legal provisions, principally the Constitution, the Code of Criminal Procedure, and various laws relating to public security. These norms guarantee the fundamental rights of individuals and define the circumstances in which a person may be arrested. According to national legislation, the maximum duration of police custody is 48 hours, renewable twice for a total of 96 hours. This extension requires written authorization from a prosecutor or judge, and in cases involving state security, the duration of police custody may be extended beyond 96 hours, sometimes up to 15 days, with the authorization of the competent judicial authorities. The arrested persons have the right to immediately notify their family or a person of their choice. Some of the sources that we have come across indicate that the standard applicable to police custody is not always respected by judicial police officers, particularly where minor offenses are concerned. In accordance with the provisions of Article 118, paragraph 2 of the Code of Criminal Procedures, and I quote from the article, any person with a known place of residence may not, except in the case of crime or flagrant misdemeanor, and if there is serious and corroborating evidence against him or her, be held in police custody, unquote. However, people whose place of residence is known are often held in police custody for minor offenses, either to please the complainant or to pay a fixed amount for their release. The time limits laid down by law for the duration of police custody are not respected in practice, in that the law provides for a single extension of police custody unless an exceptional measure is decided by the public prosecutor. In practice, however, police station and gendarmerie brigades sometimes, as I mentioned before, extend custody for up to 2 weeks. With regard to the authority to order police custody, Article 81, paragraph 2 stipulates that, and I quote, judicial police officers do not have the authority to order police custody, recognizing that this prerogative belongs solely to public prosecutors. In practice, however, judicial police officers decide to detain citizens in disregard of the law and in violation of Article 86, paragraph 1, which provides them the power to decide on special custody which may not exceed 24 hours. We would like to invite you to present us the most relevant measures that have been taken to implement fundamental legal safeguards to prevent their breaches and take to ensure the standards in places of detention, and namely in police detention units and gendarmerie detention facilities. Under Cameroonian law, arrests are governed by a specific provision of the Code of Criminal Procedure, as well as by other legislative and regulatory text. An arrest must be ordered by a judge through an arrest warrant in accordance with Article 91B of the Criminal Procedure Code. This warrant is issued when there is a solid evidence or reasonable grounds to believe that a person has committed a crime. Arrest can be made without a warrant in cases of flagrante delicto, reasonable suspicion based on serious or corroborating evidence, particularly in urgent cases where it would be difficult to obtain a warrant immediately, and for an imminent threat according to Criminal Procedure Code. This is notably provided for in exceptional contexts such as the fight against terrorism or threats to national security under specific security law. Since 2017, hundreds of arrests without a warrant have taken place, notably in situation of post-election protest or as part of the fight against armed groups such as Boko Haram in Cameroon far north and separatist group in the southwest and northwest regions. It can be seen that in this situation, there is a tendency for the abusive use of warrantless arrests in order to avoid any judicial review. Those arrested in these circumstances have still not been have still not been brought before a judge within 48 hours in accordance with Article 19 of the Criminal Procedure Code. So my question to you is, what is the current situation and what measures have been taken to reduce cases of arrest without warrant and judicial review? Now I would like to turn to access to a lawyer. From the outset of police custody, these are the provision of Article 122 of the Criminal Procedure Code. He or she may be assisted by a lawyer during questioning, except in certain urgent or terrorist circumstances. Report and observation indicate that some people have been deprived of their liberty without having been able to communicate with their family members, friends, or counsel, particularly in cases involving political activists, journalists, human rights defenders, and terrorist suspects. The law provides that a terrorist suspect could be held indefinitely in investigative detention with the authorization of the prosecutors. In cases involving terrorism or other serious offenses, such as those related to state security, suspects are often held in prolonged police custody without access to a lawyer. These violations are justified by the authorities under the guise of the fight against terrorism. Human rights organizations have reported numerous cases where suspects, particularly in English-speaking regions, have been deprived of legal assistance for prolonged periods, increasing the risk of torture or forced confessions. Now, I would like to have some clarifications on the procedure that ensure the access to a lawyer for those under the arrest. So, after how long is a detainee guaranteed access to communication with their relatives, family members, and legal counsel after their arrival in a detention facility? On what grounds may a judicial police officer or state counsel extend the duration of pretrial detention past 48 hours? Please provide the number of cases in which this is happening during the reporting period, if you have the figures. Under what circumstances or standards are those under arrest held without bail? Please explain the application process for legal aid, including free legal aid, and does the state party inform detainees of their right to access legal aid, including free legal aid? If so, how soon after detention are detainees informed of this right? And please let us know about any measures taken by the state party to make this process more accessible. One issue that caught my attention is the existence of the provision on compensation for abusive police custody, which is stipulated in Article 236 of the Code of Criminal Procedure. This particular article stipulates that any person held in police custody beyond the legal time limits or without valid justification is entitled to compensation for the harm suffered. The amount of compensation depends on the seriousness of the harm suffered, loss of income, damage to reputation, etc., and is set by the judge. However, there is no standard amount laid down by law, and each case is assessed individually. In addition, the effective implementation of these rights remains a challenge due to the slowness of legal proceeding, the difficulty of proving abuse, and the political pressure exerted on the judicial system. These provisions are as progressive as they are confusing, and I would appreciate an answer on the real situation. Therefore, could you tell us if these provisions are applied and whether this mechanism is really functional? If you have some statistics, we would be grateful to receive it. Now, I would like to refer to one of the most important safeguards against torture and ill-treatment, which is access to a doctor. In your report, there is no specific information on access to a doctor in police custody, except for the medical care and medical services provided to those convicted. Therefore, we would like to invite you to present us more information about medical examination upon admission to police custody, including the procedure of identification and documentation of signs of torture and other relevant activities related to the treatment of detainees. So I have some questions regarding access to medical care under the police custody? Do the police detention units and National Gendarmerie detention facility keep injury register and medical records? Are there internal regulations that provide for the procedure for reporting injuries or trauma? What is the procedure for administering medication to the sick in police custody and transfer to the public hospitals? Do the doctors or medical nurses performing these examinations on admission to a police detention or pretrial detention center report to the police headquarters or national gendarmerie or to a specific health authority? We understand all the constraints that you have on hiring medical personnel and providing medical care and medical equipment. Nevertheless, we hope that you can give us some answers as to how this important safeguard is implemented in practice. The next issues that I would like to address in this part of our dialogue is the work of the Human Rights Commission of Cameroon. According to your report, the Commission can carry out impromptu or notified visits to all places of detention, civilian or military, including unofficial places. The Commission shall carry out all necessary inspection and access any places of alleged human rights violation. It shall carry out regular visits to all places of detention and initiate constructive dialogue with authorities in charge of the administration and management of places of detention or any other authority. Whether the visits are impromptu or notified, the State Council, the State Prosecutor of the Military Tribunal, or head of the place of detention shall not oppose the mission of the Cameroon Human Rights Commission. These authorities shall also be expected to provide all information required by the Commission. I have a few questions regarding the Commission's competence, mandate, and work of the Subcommission on the Prevention of Torture, and its access to all places of detention and their ability to conduct confidential interviews with detainees. So my first question refers to the fact that to the possibility of the Human Rights Commissioner representative to have access to all places of detention or not. It wasn't clear from your report if they have access to psychiatric establishments, social closed institution, military units, and secret service detention facilities. Also, we want to receive information about the number of monitoring visits, major findings and recommendations that have been taken into account by the government. Also, we want to know if the Human Rights Commission reports are public. Another relevant topic is the Commission independence. How is the functional and budgetary independence of the National Human Rights Commission ensured? As I have learned, the commissioners are appointed by the president, but in the state party report, there is no information about the budgetary independence and human resources in this national human rights institution. If I understood correctly, the Commission, the Human Rights Commission, has taken over the national preventive mechanism function, even though Cameroon has not yet ratified the optional protocol to our convention. In the state party report, in paragraph 59, there is only one sentence about the subcommittee on prevention of torture. And we would appreciate if you could provide us with more details on how the subcommission on the prevention of torture works, how the visits are conducted, and to which places of detention, what are the main findings and recommendations, where are the reports following the monitoring visits published, how many places of detention have been visited by the current composition of the subcommission, are medical professionals, including psychiatrists, part of the subcommission monitoring team visiting detention facilities, and who decides which institution to visit and when. Also, we want to receive information about specific budgetary or logistical resources that have been allocated to the subcommission so that it can fulfill its mandate independently. Cameroon has joined 9 of the 18 international human rights treaties and optional protocol, including the convention. However, it has not ratified the optional protocol to the Convention Against Torture, which includes establishment of national preventive mechanism, and no tangible progress has been confirmed, except for the information in the opening statement provided by the head of delegation. So we would like to invite you to an exchange of views on the ratification of optional protocol and the establishment of an independent national mechanism for the prevention of torture. Governments change. The priority of governments may also change, but what remains constant are the positive obligations of states, which stem from their accession to international human rights convention and treaties. In this regard, we would appreciate the official position of the Cameroon authorities on the signing and ratification of the OPCAT and the possible perspective of the strategy of transparency of places of detention. With regard to independent monitoring of places of detention, I would like to draw your attention to the fact that independent monitoring of prisons is inconsistent. Non-governmental organizations and lawyers report prison access was significantly curtailed during the last 2 years, and the government does not allow independent human rights group access to review prison conditions, and group reported prison access depended greatly on the relationship between group leaders and prison officials. NGOs that implemented government-approved projects in prison reportedly had easier access. So we invite you to elaborate on this important topic for our committee and for your penitentiary and police detention facilities. Do the human rights NGOs have access to all places of detention? Do you have any particular norms or regulations that at the national level that allows for such access to places of detention? And now I would like to move to the next topic, gender-based violence, domestic violence, and harmful practices. The armed conflict within Cameroon has exacerbated the issues of violence against women, which increased reports of domestic violence. Internal conflicts, budgetary constraints, cultural reminiscence are among the biggest challenges increasing violence against women. The committee is fully aware of the efforts made by the state party to prevent domestic violence and gender-based violence and to protect victims of such phenomena. We welcome the legislative and policy efforts, including the adoption of important national strategic documents on prevention of gender-based violence. We also thank you for the information presented in the report on the trainings and awareness campaign carried out in 10 regions of the country, campaign in schools and in the media, cooperation with UN specialized agencies and other international entities in order to provide support to the victims and survivors. While welcoming Act number 007 of 12 of July 2016 on the Penal Code, which establishes new offenses, including offenses related to violence against women, the committee is concerned at reports that complaints filed by victims, investigation and convictions are few in number. The committee notes that although several reduction and prevention measures have been taken, the reality shows that in some regions, harmful practices that are condemnable under international instruments and unacceptable from a human rights point of view persist. I'm referring to stereotypes and harmful practices such as child and forced marriages, female genital mutilation, breast ironing, the stigmatization of widows and widowhood rights, kidnapping of children, especially young girls, for the sale of organs or magic religious practices. Despite criminalization of such acts within the Penal Code, victims of sexual violence and female genital cutting continue to lack assistance from law enforcement, and perpetrators continue to act with impunity. The armed conflict between the Anglophone and Francophone regions of Cameroon has exacerbated the incidents of violence against women, especially in rural areas. Women experience many human rights violations, including killings, abduction, and arbitrary arrest due to the lack of protection. In rural areas, displaced people may not be able to receive protection and thus are unable to properly report abuse due to lack of identification documents. Women, especially in remote areas, face significant barriers to healthcare with little to no access to basic medical care in hard-to-reach areas. The armed conflict has resulted in mass healthcare facility closures, with those that remain open operating at limited capacity. Additionally, as abortion is outlawed, many women are forced to seek unsafe abortion and seek unsafe or delayed abortions. Please provide statistical data disaggregated by type of offense, age group, minor, adult, region concerned, Francophone and Anglophone, and ethnic origin or nationality of the victim for the period since 2017 on cases of violence against women and children, including sexual violence, trafficking in persons, female genital mutilation, and breast ironing. Please include the number of cases recorded, complaints submitted, investigation open, prosecution brought, judgment and sentences handed down, and reparation provided to survivors of violence during this period. What other methods of redress are available to victims of violence against women and girls? What measures has the state party taken to prevent and combat FGM, and what financial allocation and redress scheme has the state party provided to victims of FGM? Please clarify whether the state party has completed the revision of the National Plan of Action for Combating Female Genital Mutilation, or when it envisions their completion. There is no legislation in Cameroon that specifically criminalizes domestic violence, and correct me if I'm wrong. No national legislation that provides preventative measures that address the underlying causes of domestic violence, nor are there any measures to promote the protection of survivors. Additionally, domestic violence remains a significant concern, potentially due to the inefficiencies in the law and the reported tendency by the police to dismiss domestic violence as a family or private matter. Thus, what steps has the state party taken to amend the penal code to make domestic violence and marital rape criminal offenses? I would like to hear your responses on what stage you are with the discussion on criminalizing the above mentioned type of violence. I have read in several sources that in recent years, measures that have been taken to support victims of gender-based violence with dignity kits and economic kits, which is with no doubts a positive action. What other protective measures are available in the country for victims of domestic and gender-based violence? Are there safe spaces, shelters, and what is their capacity? What services are provided for victims of trafficking and domestic violence in those shelters or safe spaces? The next topic I'd like to discuss with you is quite complex and raises numerous concerns, and I'm referring to the migration, asylum procedure, and protection of migrants and refugees and internally displaced persons. These are questions and issues that fall under Article 3 of our Convention, and which by definition represents a multitude of difficult aspects generated both by the vulnerability of these people, lack of legal provision and adequate mechanisms to protect these people, and the reality that exists nowadays in Cameroon. Despite of the problems that exist in the area of protection of refugees, there are also some indications to positive trends. The government cooperates with the Office of the United High Commissioner for Refugees and other humanitarian organizations present in the region in providing protection and assistance to refugees, returning refugees or asylum seekers, as well as other persons of concern. The committee is concerned about the continued uncertainty surrounding the procedure for determining refugee or asylum seeker status in the state party. The committee is also concerned at reports that refugee and asylum seekers from Nigeria have been ill-treated by the armed forces, and there have been mass forced expulsion of such persons for alleged collaboration with terrorist movements. Now, a couple of words on access to asylum. The law provides for the granting of asylum or refugee status, and the government had a system for providing protection to refugees, but implementation of this system is weak. UNHCR continues to provide documentation and assistance to the refugee population, although local authorities did not always recognize the documents as official, which prevented refugees from traveling and engaging in employment activities. Freedom of movement. One of the most common problems that transpire from various relevant reports is that the government generally did not provide identity documents in a timely manner to refugee and other person in need of primary documentation, and UNHCR issued cards were often insufficient to permit refugees to travel freely and integrate socio-economically in the country. We are interested in how this situation is solved. What legal and practical solutions do you have in order to recognize these documents and offer the necessary protections to refugees? Concerning employment, although there were no credible reports that the government restricted refugees' ability to work after their refugee status was official, the government delays in providing identity documents was an issue, as the refugee without such documents faced significant obstacle to employment in the formal sector. So we want to ask you, how does integration of refugee and asylum seeker into the labor market take place? What other employment barriers are there, and how do you address them, apart from the identity documents? There was no evidence the government accepted refugees for resettlement or offered naturalizations to refugees residing in its territory. The government assisted in the voluntary return of persons to Nigeria and the Central African Republic. The government continues to provide temporary and unofficial protection to individuals who might not qualify as refugees, extending this protection to hundreds of individuals, including persons who had fled violence in the Central African Republic. Due to their unofficial status and inability to access services or support, many of these individuals were subject to harassment and other abuses by employers in the informal sector. So I have some questions to the situation regarding temporary protection. What safeguards are currently offered? We would also appreciate relevant figures on the number of people who have been granted temporary protection status in your country. We would also like to be updated on the reception condition for refugees, and we'll appreciate your answer on refugee access to vital necessities such as water, sanitation, and food. As far as I understood, there is no clear approach or mechanism to identification of vulnerable persons, including victims of torture. More broadly, we would appreciate any updates on the coordination mechanism, any recent changes in the legislation or practices aiming at improving the situation of migrants and asylum seekers, including the situation of unaccompanied children. What steps is the state party taking to ensure that the detained unaccompanied migrant children are kept separately from adults? There is no statistic in the state party report on the complaint mechanism available for refugees and migrants, and we would like to ask you how many complaints have been submitted by such people and how many of them have been investigated. In addition, we would like to know what measures have been taken by the government in order to ensure that these refugees are not subjected to torture and ill treatment when returned to their country of origin. Do you have established procedures to identify victims of torture among refugees who fled their country and resides in Cameroon? As I mentioned, is there a complaint mechanism? Can refugee report any problems, and which exact state authorities deal with the refugee complaint. It wasn't clear from the information provided in the state party report. A specific problematic area is the situation of internally displaced persons. According to UNHCR estimates, there were more than 1 million IDPs in 2023. Reports indicated IDP girls and women were particularly vulnerable to sexual exploitation. And we want to receive information about the status of internally displaced people in Cameroon and what challenges do they face. Who is providing assistance for IDPs in the country, and what measures or solutions are in place for addressing the displacement? More precisely, we want to receive information on measures taken to prevent violence, including sexual exploitation of women and girls among IDPs. To conclude, our committee calls upon Cameroon to avoid taking measures that could lead to the forced displacement of the population and to take appropriate, reasonable measures to prevent such displacement. Another important topic to discuss in this dialogue is death in custody. States have a responsibility to ensure that detained individuals are protected from harm and ill treatment. Death in police custody or prison are a matter of great concern and an expression of the ultimate failure in the duty of care of corrective services, depicting a detention system in crisis. They may be due to natural causes, such as an aging population, but they may also be due to the detention environment, ill treatment, or inadequate conditions of detention, which directly lead to death, police brutality, interprisoner violence, drug addiction, suicides, and so on. We appreciate that in your report, you provided a statistic on death in custody between 2018 and 2020. According to the data in your report, the deaths were caused by various diseases, including HIV, AIDS, and other infectious respiratory diseases. However, several sources talk about the fact that a large proportion of deaths in custody are caused either by violent incidents between detainees or as a result of unlawful action and excessive use of force or torture by law enforcement. Bearing in mind that the statistics presented do not reveal the causes of the death, we would like to have some clarifications. Since your report does not clearly explain the procedure for reporting and investigating of death in custody, we would like to ask you what are the standard procedures used for the examination of bodies? Please elaborate on the procedure for reporting cases of death in custody. Who can report a case of death in custody? What barriers are there to report a case of death in custody? What measures has the state party taken to overcome such barriers? Please elaborate further on the provided statistical data on death in custody during the reporting period, indicating the place of detention, sex, age group, and ethnic origin of the detainees who died. In paragraph 24 of the list of issues prior to reporting, the committee requested statistical data indicating the number of deaths in mental health facilities and police stations, disaggregated by the individual sex, age group, ethnic origin, the cause of death, year, and facilities. We need to reiterate our request, so please provide this data now. The committee has also requested the state party to provide detailed information on the number and outcome of investigation conducted in these cases, specifying whether a forensic medical assessment, including an autopsy, was performed, and the number of deaths in mental care facilities and prison stations believed to have been caused by assault committed or tolerated by government officials involving excessive use of force or the failure to provide the detainees with the necessary medical attention and treatment in time. And we would like to receive your comments on this. One of the obstacles affecting the investigation of death in custody is the fact that the cost for autopsies or forensic examinations are not covered by the state, and this high cost cannot be covered by the victim's family members. So this I learned from some submission coming to the committee. And I would like to know if this is true, and if there are situations where this cost can be covered by state budget. I didn't find any relevant legislation in this respect. So we want to be updated about the measures taken by the state party in order to prevent violent incidents among prisoners, including self-mutilation and suicides. Under international law, states have an obligation to investigate all deaths, serious injuries, and disappearances of persons that they detain, regardless on how the incidents occurred. The obligations to carry out investigation is an integral part of the right to life and the prohibition of torture and other cruel, inhuman, or degrading treatment or punishment. In particular, state authorities must carry out an independent, impartial, prompt, and effective investigation into the circumstances and causes of any death in prison, to provide reparation or redress to families, and to hold to account individual perpetrators of unlawful killings. This obligation is applicable to all prison deaths, regardless of the cause, in each country or in each member state to our convention. Now I would like to move to the next part of question that refers to overcrowding and conditions of detention. So regarding prison conditions, I would like to thank you for the update on the several measures taken by the government during the reporting period to improve the material conditions of detention, including the construction of new prison facilities and the increased budget for food. These are quite positive trends. In the past, Cameroon was repeatedly criticized by various human rights international mechanisms and local NGOs for the poor conditions of detention and overcrowding. The exponential increase in the number of persons deprived of liberty derived from a penal system that promotes custodial sentences, ensures the continuity and worsening of the inhuman conditions in your penitentiary system. The absence of specialized facilities for women raises gender-sensitive issues, and due to the lack of access to basic facilities, most people are living in conditions that amount to ill treatment and sometimes torture. Prisons in Cameroon face inadequate access to food, water, sanitation, heating, ventilation, lighting, and medical care, leading to rampant malnutrition, tuberculosis, malaria, hepatitis, scabies, and other treatable conditions, including infections. COVID-19 was also widespread among inmates, with over 4 deaths reported at the Yaoundé Central Prison in April 2021, and the outbreak of cholera in 2022 in Douala New Bell Central Prison, with dozen deaths that occurred in 2022. In Cameroon, there are currently 79 functioning prisons with an intended capacity of almost 18,000 people, according to prison administration officials. However, only one prison, and sorry for the pronunciation, the Monfou Women Prison Facility in Yaoundé, is specifically designated for women due to the gender-neutral approach of the Cameroon Penitentiary Regulation, which fails to account for the unique needs of female inmates. Nevertheless, some prisons like the Yaoundé Central Prison have special quarters for incarceration of women and of juveniles. As of June 2022, the overall prison population was more than 33,000 prisoners. Women make up 2.6% of this population, and juveniles below of 18 years old also make up 2.6% of this population. In Cameroon, overcrowding is a pervasive issue in many prisons, particularly in major urban centers. And according to publicly available information from the last years, the rate of overcrowding continued to be around 170%. For instance, the central prison in Ngaoundere, Adamawa, was initially designed to hold 150 inmates, but subsequent expansions raised its capacity to 500 inmates. As of June 2018, the prison held 1,600 inmates, with over 70% of them under pretrial detention. The Douala New Bell Prison, with a capacity for 800 inmates is also severely overcrowded, and in 2022, it was estimated to house at least 5,000 individuals. Overcrowding in cells has been linked to an increase in poor mental health, as many prisoners are forced to share a single space for eating, sleeping, and using the toilet. Overcrowding in the prison has also been linked to an increased rates of violence and self-harm. According to some reports, most persons deprived of their liberty are not offered physical, recreational, educational, and work activities of any kind. The lack of educational opportunities explain the high recidivism of inmates and the increased number of violent incidents among prisoners. I am fully aware about the budgetary constraints your government faces, but also other challenges and crises in several regions of the state. I want to encourage your government to make use of this dialogue to inform the international community about the shortcomings you have in the prison system, but also about the solutions identified to overcome them. Therefore, we would like to get a holistic response that would include administrative, legislative, judicial measures aiming to reduce the prison population and improve material conditions and level of staffing, including medical personnel in your correctional facilities. So what is your strategy for improving detention condition, reducing overcrowding, including your strategy on the use of non-custodial penalties as an alternative to deprivation of liberty? In March 2020, the head of state had issued a decree commuting and reducing prison sentences, which had benefited over 10,000 prisoners. And we would appreciate some additional information on the presidential decree and its impact on the number of prison population in your country. How do you manage to solve the problems related to the infrastructure of the old detention units? What are your plans in respect to the conditions of detention in police detention, but also in the gendarmerie detention units? In line with the above mentioned findings and constraints, we want to receive updated statistical data regarding capacity rate per prison and prisoner rates per cell and measures provided to reduce overcrowding in prisons, updated data per prison on the average amount of living cell space per individual, and we would appreciate any relevant information and data regarding the measures that the state party have been taking in order to improve the material conditions of detention. In order to conclude, I would like to convey a positive obligation, to remind you about positive obligation under our convention that require that Cameroon must ensure access to proper and permanent medical facilities with well-trained medical personnel in all prison and detention centers. The government.
Thank you very much, Ms. Raku, and I will now give the floor to Mr. Jorge Contes.
Muchas gracias, señor presidente.
Thank you, Mr. Chairman. I would also like to thank the delegation of Cameroon, headed by the ambassador, for their presence here at this interactive dialogue with the committee. And I would like to congratulate Cameroon on electing Mr. Philomène, former Prime Minister, as President of the General Assembly of the United Nations. That election, as well as the official visit by the High Commissioner for Human Rights to Cameroon last August, points to Cameroon's role in promoting the values that unite the international community, which must be promoted and protected, including the absolute prohibition on torture. Mr. Chairman, I plan to address the following points. Definition of torture as a crime and appropriate punishment. Second, jurisdiction of military courts over civilians. Third, extradition of torture suspects. Fourth, training and survey methods. 5, prompt impartial investigation and victim protection. 6, inadmissibility of statements obtained via torture. 7, prevention of other cruel, inhuman or degrading treatment. Mr. Chairman, for reasons of time, I might not go through all of those points. I might leave some for tomorrow. I will make my presentation in French and English, the two official languages of Cameroon, starting with Articles 1 and 4, definition of torture as a crime and appropriate punishment. In the concluding observations, the committee noted that Article 277(3) of the new 2016 Penal Code contained a definition of torture in line with Article 1 of the Convention, but the committee expressed concern that the article does not provide for an appropriate penalty insofar as the minimum sentence for an act of torture is 2 years imprisonment, which means that the sentence could be suspended. The committee is also concerned that in accordance with Articles 90 and 91 of the Criminal Code, the penalty for an act of torture may be reduced to 1 year's imprisonment in cases where the court recognises mitigating circumstances. The committee expressed concern that most of the sentences handed down for acts of torture were very light and that the offence of torture is subject to the statute of limitations. What steps has the state party taken to amend its criminal code to bring it into line with Article 4(2) of the Convention and ensure that neither statute of limitations for criminal and civil proceedings nor mitigating circumstances are applicable in cases of torture or ill treatment? And the committee would also like to receive information on the following. How many cases of alleged torture were brought before the courts during the reporting period? How many cases of torture were tried by the courts during the reporting period? Please indicate the sentences handed down in each case. How many cases of torture are currently pending before the courts? What is the average duration of torture proceedings before the court? During the reporting period, what was the maximum duration of torture proceedings? On the jurisdiction of military courts over civilians, my colleague Ms. Raku has already touched on several aspects of Article 2 of the Convention. However, I would like to focus on one aspect in particular, namely the jurisdiction of military courts over civilians. In its concluding observations on the 5th periodic report, in the context of the investigations into the Anglophone crisis, the committee asked the state to make detainees available to the civil courts. In its report, the state party states that military courts have jurisdiction not only over offences of a military nature, such as those covered by Articles 30 to 67 of the Code of Military Justice, but also over, I cite, offences committed with firearms, those related to terrorism or which affect the security of the state. That's paragraph 48. This jurisdiction is extremely broad and compromises the state's compliance with its international obligations. Furthermore, in the case of offences under law number 2014/028 of December 23rd, 2014 on the repression of acts of terrorism, the period of police custody is 15 days, renewable upon authorization of the competent government commissioner. The committee received information that in 2018, more than 330 people were under sentence of death in Cameroon, a third of them for terrorism-related offences. The information also indicates that the near majority of death penalties were handed down by military courts, sometimes on the basis of confessions made under torture. This will be dealt with by the members of the committee, this question. However, we would like to know whether the state party intends to amend the law to provide reasonable time limits for police custody for acts of terrorism, and to abolish the jurisdiction of the military courts over civilians, and whether detainees can file habeas corpus petitions before military courts. Furthermore, please provide the text of Articles 37(1), 38, 39 and 41 of the decree on the prison system in Cameroon, which regulates family visits for persons sentenced by military courts.
Regarding the extradition of torture suspects, Articles 5 and 9 of the Convention, the committee notes that the state party has not received any extradition request from another state party for the extradition of an individual suspected of having committed acts of torture during the period under review. Please indicate any extradition agreements concluded with the other state's party during the reporting period. For all new agreements, are the offences referred to in Article 4 of the Convention included in the list of extraditable offences? During the period under review, has the state party exercised its jurisdiction over any person for the offences referred to in Articles 4, 5 and 16 of the Convention? Has the state party accepted or requested mutual legal assistance from another state party for cases of torture or ill treatment? If so, please give examples of cases and indicate the type of evidence or legal assistance provided. Please also indicate the agreements on or treaties on mutual legal assistance that the state party has concluded with other entities, including other countries, international courts and international institutions during the period under review. Articles 10, training and investigation methods. The committee notes that the state party offers human rights courses in national security, prison administration and magistracy schools, as well as a module on prohibition, prevention and punishment of torture in training programs for military personnel and gendarmes. The committee recognises that these programs do impart specialised knowledge on the individual responsibility of perpetrators, the identification of victims, the taking into account of vulnerabilities and non-refoulement. Is completion of a human rights course or training a mandatory prerequisite for employment as a public official in the armed forces, in the police forces, the prisons, or immigration and border control services? Is the prohibition,
psychologique de la torture et comment documenter efficacement la torture. Je passe maintenant aux articles 12 et 13 sur l'enquête rapide et impartiale et protection des victimes. Dans son discours d'ouverture, Monsieur l'ambassadeur a dit « Les enquêtes sont ouvertes. Les mesures disciplinaires conservatoires prononcées dans l'attente de l'issue des procédures has had access to the case file said that this was, quote, inexplicable. People close to the case, according to media reports, are beginning to doubt the judicial investigation's sincerity, and some point to the absence of certain evidence which has disappeared or was never included in the case file. The committee has received concerning reports about journalists' lack of safety in Cameroon. Reports indicate that Paul Chuta, a reporter from Cameroon Web, was forced into a car, given a severe beating, and left for dead at the side of a road on 9 March of 2022, 2 days after he posted a photo on Facebook showing the finance minister and a prominent businessman who allegedly was involved in the killing of Martinez Zogo. In another recent case, Ramon Cota, a social media activist, was apparently kidnapped in Gabon on 17 July 2024 and forcibly extradited to Yaoundé. Mr. Cota's lawyer and international human rights organizations state that Mr. Cota was subject to torture. Mr. Cota has been living in Gabon for the past 10 years and is known for his TikTok videos in which he criticizes Cameroonian authorities. We understand that Mr. Cota is currently in a cell at the Secrétariat d'État de la Défense, a prison where those deemed to be holding state secrets and therefore are a threat to the government are held, awaiting trial. We also understand that he has been placed under a 6-month provisional detention order. Reports indicate that Mr. Cota was interrogated several times without a lawyer present, both at the Direction Générale de la Recherche Extérieure and 4 times at the Service Central de Recherche Judiciaire. According to a confidential report reported in the media, Mr. Cota suffered from early paralysis on the left side and visual disturbances as a result of torture and mistreatment during his detention. In another case, a recent case of singer Longué Longué, an artist who is also known for his critical views on the government, a video of Cameroonian officers torturing him emerged. In the video, Longué Longué's hands are cuffed behind his back. He is sitting on the floor in his underwear as the soles of his bare feet are beaten with a flat machete. He pleads for the beating to stop, but the men who appear to be security agents continue. Can the delegation please specify the status of these investigations of these different cases? In the specific case of Mr. Zogo's killing, and as noted under Article 1 of the Convention, please provide additional information on the mitigating factors that downgrade the crime of torture to a charge of complicity in torture. Could the delegation specify the charges under which Mr. Cota is being held, particularly as he was not in Cameroon when he was arrested by authorities in Gabon? Have any investigations into ill treatment or torture being initiated? In the case of artist Longué Longué, have any investigations being initiated? As indicated in Cameroon's Human Rights Commission's website, the Commission wrote to the Minister Delegate at the Presidency of the Republic in charge of defense to ensure that the results of the investigation opened by him in the case of Longué Longué be known before 13 November of 2024, that is today. Could the delegation please share the specific findings on those responsible for the ill treatment and torture that is visible for the world to see? In light of the committee's previous concluding observations and the information provided in the state party's periodic report, paragraphs 126 through 128, the committee remains concerned about the ambiguity of the accountability measures relating to the cases of involving Cameroon police, gendarmes, and specifically in the cases of Buba Yauba, David Edmond Gumpung Gunitiche, Abubakari Siddiqui, and Abdoulaye Harisu, Blaise Elem Koang Yepo, and Wirba Didimus Soseka. We ask the delegation to please specify the status of these investigations into these different cases. With regard to the arbitrary detention and death in custody of Boko Haram suspects, which led to 9 investigations opened in 2018, please specify what sanctions were imposed as officers, how many officers in total were sanctioned, and whether criminal investigations have been opened or will be opened, and when they are expected to be completed. This is in reference to paragraph 18 of the committee's concluding observation, previous concluding observations. Please specify what sanctions were imposed on prison staff in 2017, how many people were sanctioned, and whether criminal investigations have been or will be opened, and when the state expects them to be concluded. This is in relation to paragraph 128 of the state party's report. Please provide detailed statistics on the number of cases dismissed and the number of cases still pending. In the light of its previous concluding observations, the committee requests information on programs for the protection of witnesses and victims of torture. Under what mechanisms and programs are witnesses and victims currently protected? When does the state party expect protection programs to be fully operational in accordance with the National Action Plan for the Promotion and Protection of Human Rights in Cameroon? I move to Article 15, inadmissibility of statements obtained under torture. Under Article 15 of the Convention, the use of any statement obtained under torture or resulting from torture is prohibited in any proceedings. The committee, in its list of issues prior to submission, paragraph 24, requested information on the measures used to ensure compliance with the exclusionary rule. The committee is concerned that the state party is unable to provide more than one case where evidence obtained under duress has been excluded. Furthermore, the committee is concerned that under the state party's Code of Criminal Procedure, only confessions obtained under torture are prohibited, whereas Article 15 of the Convention requires that all statements obtained under torture be prohibited. Does the state party recognize that Article 15 of the Convention prohibits the admission as evidence of all statements, not just confessions obtained under torture? When will the state party amend its penal code to reflect this provision? What is the standard of proof used by the courts or administrative staff to determine whether confessions have been obtained under torture? What criteria do the courts use to determine coercion, violence, or intimidation with regard to extorted confessions? Please provide statistics on the number of cases in which the exclusion rule was applied during the reporting period. How is compliance with Article 15 of the Convention monitored? Does the admission of evidence obtained by torture constitute grounds for appeal in any judicial or administrative proceedings? Please provide data on appeals based on information derived from torture including the number of appeals accepted and rejected. Are decisions reversible on appeal if it is established that evidence falling under the exclusion rule has been used in court or in administrative proceedings? With regard to capacity building sessions for judges, why were criminal judges not included? Does the state party have any other methods of training criminal judges? In the case of John Phai Phuong Gong, a victim of torture inflicted by state agents, as shown once again in a video published on social media in February of 2021, which state authorities strongly condemned at the time. Can the state provide information on the results of investigations? Have those responsible for acts of torture in this case been convicted? If so, to what penalties? I finally move, Mr. President, to Article 16, prevention of other cruel, inhuman, or degrading treatment. The committee welcomes the state party's new community policing system, which consists of toll-free numbers for reporting human rights violations. However, the committee is concerned about the effectiveness of this system for reporting allegations of torture against state party officials. The committee notes that the state party deploys defense and security forces after a violation has been reported through the hotlines. How does the state party guarantee independent and fair investigations into allegations against state employees when state employees are conducting the investigations? Please provide statistical data on the number of people who have used the community policing figures since its implementation, the number of people who have been investigated under this system, and on the number of people who have been prosecuted and or punished. I would like to refer to the issue of mass graves. In the list of issues prior to reporting, the committee asked whether the state party had begun the process of exhumation, analysis, and identification of the bodies in the alleged mass graves, including a mass grave at Mindif. In its sixth periodic report, the state party denied any knowledge of such mass graves. The committee remains concerned by reports of mass graves in the Republic, particularly after the state party's military officials located a mass grave in 2023. Please indicate the measures taken by the state party to investigate allegations of mass graves, particularly in Mindif. Please explain the systems in place to enable civilians to report suspected mass graves for investigation by the state party. Please indicate whether the state party would exhume, analyze, and identify bodies at the site of a mass grave if its investigation revealed the presence of a mass grave. Finally, in the list of issues prior to reporting, the committee requested data on a long list of cases. The state party provided information on some of these cases in its sixth periodic report. Therefore, the committee reiterates its request for data for the period since 2017, disaggregated by type of offense and gender, age group, and ethnic or regional origin of the victim for these cases. Please also share any individual information on the progress of these cases. This is referring to paragraphs 165 through 176 of the committee's concluding observations under the fifth periodic report. In particular, and I close with this, Mr. President, the events, and apologies for my mispronunciation, events in Ngarbu in February of 2020, events concerning the looting, burning of villages, and murders of English-speaking civilians allegedly perpetrated by the army, particularly in Babukok, Banjem, and Do in January 2020, and in the villages of Kwakwa, Dadi, Kajifu, and Bodam in December of 2017. Concerning the murder of 10 men in the village of Bole Bakundu on February 6, 2019, by soldiers of the Rapid Intervention Battalion. On the murder of 5 civilians, including a disabled person, on April 4 of 2019, in the village of Melouf by gendarmes and soldiers of the Rapid Intervention Battalion. Concerning the murder of a man and the destruction of houses in the village of Mancon on 15 May 2019, and the murder of 2 men on 10 July 2019. On the July 2018 murder of 2 women and their children accused by the Cameroonian army of being members of Boko Haram. Concerning the murder of 4 civilians and the enforced disappearance of 2 others on 26 June 2018 in the village of Muri, far north region, by armed soldiers. Concerning the murder of 2 unarmed men by soldiers of the Rapid Intervention Battalion in a Buea neighborhood known as Great Sopo on 24 September 2018. Concerning the death of 4 people in the far north region in April 2015. And the death of a man attributed to the FDS during an operation to arrest Indian hemp growers on 4 September 2017 in the village of Kifen. Thank you, Mr. Chairman. I stop here my presentation.
Gracias, señor Contese. A continuación, ofrezco la palabra a otros miembros del comité que desean intervenir. Tiene la palabra el señor Iscan.
Thank you, Mr. Chairman. May I first extend a cordial welcome to the distinguished ambassador, as well as the esteemed delegation of Cameroon. My remarks and questions will be related to obligations of the state party under Article 14 of the Convention. Having examined the concluding observations of 2017, the list of issues of 2020, as well as the report submitted by the state party in 2022, I will first recall that the committee requested information on the legislative and administrative measures to ensure that victims have access to effective remedies. Meanwhile, the committee emphasized the importance for the victims to obtain redress even when the perpetrator has not been identified or found guilty. The state party was also invited to provide data on redress and compensation measures, including means of rehabilitation ordered by the courts and actually provided to victims or their families. The committee takes note of the information contained in the 6th periodic report, in particular in paragraphs 143 through to 148, with respect to compensation measures and specialized rehabilitation services. At this juncture, let me underline that under Article 14 of the Convention, each state party is required to ensure in legislation and practice that the victim of an act of torture and ill treatment obtains redress. The term redress is a comprehensive concept. It covers restitution, compensation, rehabilitation, and guarantees of non-repetition. The Convention establishes that all these components need to be implemented in a coherent and complementary manner. I should like to draw the attention of the State Party to General Comment number 3 of the committee, whereby a comprehensive interpretation of obligations under Article 14 is provided. Full rehabilitation requires a holistic approach. Rehabilitation for victims should aim to restore their independence and full inclusion in society. Victims need to see that justice is done. Under its mandate, the committee needs to review the steps taken aimed at aligning the legislation with the Convention standards and to observe the outcomes of policy and legislation in practice. This is an essential requirement for the committee to be able to make a thorough assessment that will constitute the basis for developing appropriate recommendations to assist the State Party to make progress towards full compliance with the obligations under the Convention. Now I will highlight the progress made and the remaining concerns. The committee commends the State Party for establishing the Commission for Compensation for Illegal Detention that commenced functioning. The committee notes the information contained in the report that damages have been awarded to victims and that the government works in collaboration with non-governmental organizations that are involved in the rehabilitation of victims of human rights abuses. The committee invites the State Party to provide up-to-date information on the functioning of the mechanisms, including the Commission for Compensation for Illegal Detention, since the submission of its report in January 2022, almost 3 years ago. The committee requests the State Party to supply concrete examples involving continued collaboration with non-governmental organizations, indicating statistical data as requested in paragraph 23 of the list of issues prior to report. Furthermore, the committee invites the State Party to supply data in response to the following questions. Is the Commission for Compensation for Illegal Detention furnished with necessary mandate and provided with required financial and human resources to compensate all torture victims? How does the State Party ensure that all victims of torture receive redress, particularly in circumstances when the perpetrator is unknown, as described in General Comment number 3? What is the procedure for the Commission to make the compensation available to victims? How many victims have been granted compensation by the Commission to date? Does the State Party plan to further improve rehabilitation programs in order to cover all victims? Does the collaboration with non-governmental organizations with respect to providing rehabilitation to victims function effectively? I thank you, Chair.
Gracias. Tiene la palabra el señor Buchwald.
Excuse me. Thank you, Mr. Chairman. And let me join my colleagues in welcoming the Ambassador and the delegation. It's a pleasure to have you here today. I had 2 questions about your statutory provisions on torture, Article 277-3. The first one was triggered by paragraph 7 of Article 277-3. Paragraph 7 says that an order from a superior or public authority may not be invoked to justify torture. So that's good. That's an important principle, of course. But to say that a subordinate cannot invoke an order from a superior, that's not the same as saying that the superior can be criminally responsible for allowing or tolerating the acts of his subordinates. And so my question is there a specific provision in your law that provides that a superior can be criminally responsible for the acts or omissions of an inferior, of a subordinate? And what I'm talking about are cases where the superior knew or should have known, ought to have known, that the subordinates were committing or were about to commit torture, and yet failed to take all necessary and reasonable measures within his or her power to prevent or repress the commission of these acts, or to submit the matter to the competent authorities for investigation and prosecution. The second question I had, so that's the first question. The second question related to paragraph 5 of 277-3, which says unobjectionably, it says the term torture so defined does not include pain or suffering arising from inherent in or incidental to lawful sanctions. And of course, that's taken from the convention itself, but can have a different effect in international law than it has when it's incorporated into domestic law. And so my question about this is whether this phrase has been interpreted or is understood to mean to refer to sanctions that are lawful under domestic law, sanctions that are lawful under international law, or both. And because, so I'll leave it at that. That's my question. So thank you very much.
Gracias. Le doy la palabra al señor Kessing.
Thank you, Mr. Chairman, and also a very warm welcome to the delegation, esteemed delegation from me. Very good to have you here, and thank you for this dialogue. I have two questions. First one concerns the situation of human rights defenders. We have received reports that human rights defenders are arrested, tortured, and receive very long sentences. They are allegedly exposed to treatment in breach of our convention. For example, a journalist, I apologize for my pronunciation, Kinsley Fomoni Nkoya, was on the 24th September 2024 exposed to harsh treatment and sentenced to 10 years in prison. Reporters Without Borders has condemned this sentence and called it absurd. The committee is concerned about the length and the fairness of proceedings and the harsh punishment of human rights defenders. So could you please explain and assure the committee that journalist Kinsley Fomoni Nkoya received a fair trial in line with our convention? And furthermore, could you please inform the committee which steps you have taken to ensure that human rights defenders are not exposed to ill treatment and receive a fair trial in line with international standards? My second question relates to the rights of LGBT+ individuals. Section 347 of your penal code prohibits, prohibits sexual relations with a person of the same sex. The committee notes the state party's positions described in the state report that, and I